The day my sister stood up in a room full of people and told everyone I had stolen from our father. I was sitting 4 chairs away from her, wearing the only suit I owned and holding a folder of documents that I had not yet opened. She said it loudly. She said it with the specific confidence of someone who has rehearsed the moment so many times that the delivery has become automatic. She said I had manipulated an old man in the last months of his life. She said I had taken advantage of his declining health to redirect what should have been shared equally between us. She said it to a room that included our extended family, our father's lifelong friends, 2 neighbors who had known us since childhood, and my father's pastor, who sat in the second row with his hands folded and his expression carefully neutral. She said all of it, and then she sat down and looked at the attorney across the table with the satisfied expression of someone who has just completed the first move of a game they are certain they will win. What she did not know, what no one in that room knew yet, was that the folder in my hands contained the documents that would dismantle every word she had just said. And my attorney, a woman who had spent 23 years in probate litigation and who did not waste language on anything that could not be proven, was about to open her own folder and begin. My name is Nathan Cole. I am 44 years old. I am a high school science teacher in Indianapolis, Indiana. I have been teaching for 16 years, and I have a classroom full of teenagers who are, on a daily basis, more honest with me than many adults I have encountered in my adult life. I live in a house that I bought 8 years ago with a down payment I saved from teaching and tutoring and summers spent doing whatever work I could find. I am not a man of significant financial resources. I am a man of significant patience, which turned out to matter more. And the story I am about to tell you is the story of how my sister, who had more money than I did and more confidence than she had earned, and a plan she had been building for at least 3 years, made the specific and fatal mistake of underestimating a high school science teacher with a folder full of bank records and an attorney named Margaret Okafor who knew exactly what to do with them. Welcome to the Revenge Diaries. If you are new here, subscribe right now and hit the like button. This community is built for real stories told with complete honesty. And before I go any further, have you ever been publicly accused of something you did not do by someone who knew you did not do it? Drop that in the comments. I want to hear from you. Now let me take you back to where this started, because the ending only makes sense if you understand the beginning. My father, James Cole, was 69 years old when he was diagnosed with early-stage Parkinson's disease. He was, at that time, still sharp, still driving himself to appointments, still managing his own finances, still calling me on Sunday evenings the way he had called me every Sunday evening since I left for college. He was a retired machinist who had spent 34 years working for a manufacturing company in Indianapolis, and who had, over those 34 years, done something that surprised almost everyone who knew him. He had saved. Quietly, consistently, without discussion, he had saved. He had paid off his house. He had contributed steadily to a retirement account. He had purchased in his early 50s 2 small rental properties on the east side of Indianapolis that had provided steady income for nearly 2 decades. He was not wealthy by any standard that required a conversation about wealth, but he had built something real. And the something real, by the time of his diagnosis, had a value that my sister Renata had been aware of for longer than she had admitted to anyone. Renata is 4 years older than me. She is 48 years old. She works in pharmaceutical sales, which means she is organized and persuasive and has a very high tolerance for the specific kind of performance that involves saying what a room needs to hear. She lives in a large house in the northern suburbs that she shares with her husband, a financial consultant named Brad, who has the specific kind of quiet that means he understands what is happening and has decided not to involve himself. Renata has 2 children who attend private school. Renata drives a car that I could not afford. Renata had, for the years before my father's diagnosis, maintained a relationship with him that was warm in its surface presentation and functionally thin underneath. She visited on holidays. She called on birthdays. She sent the grandchildren to spend occasional weekends. But the day-to-day reality of my father's life, the doctor's appointments, the prescription management, the grocery runs, the Saturday mornings, sitting at his kitchen table, drinking coffee while he talked about whatever was on his mind, that was mine. Had been mine for years, not because it was assigned, because I lived 30 minutes from his house, and she lived an hour and 15 minutes from his house, and I had always been the one who showed up. I want to be careful here, because I have thought about Renata's motivations a great deal over the past 3 years, and I do not think she is simply a greedy person in the straightforward sense. I think she is a person who looks at the world through the lens of what is owed to her and who had calculated, at some point in the years before my father's diagnosis, that her position as the older child and the more financially sophisticated child entitled her to a larger share of whatever my father left. I think she had been constructing that justification for a long time, and I think the diagnosis, which accelerated the timeline in her mind, caused her to begin implementing a plan that she had been developing quietly and that I had not known to look for. The first sign came 14 months before my father died. He called me on a Sunday evening in October, which was normal, but the call felt different from the beginning. He was less fluid than usual. He stopped in the middle of sentences. He said, "Nathan, Renata has been talking to me about some things." I said, "What kind of things, Dad?" He said, "Financial things. She says she wants to help me organize everything." I said, "Okay, do you want help with that?" He said, "I think I want to talk to someone first." "An attorney." I said, "I think that's a good idea." He said, "Will you come with me?" I said, "Yes." And that yes, that single Sunday evening yes, turned out to be the thing that created the paper trail that saved everything. My father had an existing relationship with an estate attorney named Gerald Marsh, who had prepared his original will approximately 8 years earlier. We went to see Gerald together on a Tuesday morning in November. Gerald reviewed the existing documents, and my father, in that meeting, expressed two things clearly and specifically. First, that he wanted his estate divided equally between his two children. Second, that he was concerned about some conversations he had been having with Renata about financial arrangements that he did not fully understand and that felt, in his words, like they were moving faster than he was comfortable with. Gerald noted both of those things in his records. He recommended that my father not sign any documents without legal review, and that any changes to financial accounts or property titles go through his office for proper documentation. My father nodded. He said, "Good, that's what I needed to hear." We drove home, and he made coffee, and we sat at his kitchen table, and he said, "I'm glad you came with me, Nathan." I said, "Me too, Dad." That was in November. By the following September, he was gone. And within 3 weeks of the funeral, Renata had filed a petition claiming that a will amendment executed 6 months before my father's death was the valid controlling document, and that it left the rental properties and the majority of the estate to her alone. I want to tell you what I felt when Gerald Marsh called me the day after Renata filed the petition, because I think being honest about this moment matters. Gerald called me at 7 in the morning, which told me immediately that what he had to say was urgent. He said, "Nathan, there's been a filing. I need you to come in today." I drove to his office in the rain. I sat down across from him. He showed me the petition, and I read the summary of the alleged will amendment, a document that named Renata as the primary beneficiary of the rental properties and a significantly larger share of the retirement account, with a justification attached stating that Renata had provided the majority of caretaking support in the final months of my father's life. I read that justification twice, and what I felt was not rage. What I felt was the specific, clarifying cold of a person who is looking at a document that is incorrect in a way they can prove. Because I had been there, I had records of being there. I had the calendar app on my phone showing every appointment I had driven my father to for 14 months. I had bank transfers showing grocery purchases I had made on his behalf. I had text messages. I had Gerald's November meeting notes. And I had something else, something I did not yet fully understand the significance of, that my father had given me 6 weeks before he died. He had handed me an envelope. We were at his kitchen table on a Saturday morning, the specific quality of late summer light coming through the window over the sink, and he slid the envelope across the table and said, "Keep this somewhere safe. Don't open it until you need to." I had put it in the fireproof box in my closet, and I had not thought about it again until the morning Gerald Marsh called me. I went home from Gerald's office that day, and I opened the fireproof box, and I took out the envelope, and I sat on the edge of my bed, and I opened it. Inside was a single folded page, in my father's handwriting, dated 6 weeks before his death. It said, "To whoever needs to know this, I have been asked to sign documents that I did not fully understand." I was told they were routine. I did not believe they were routine. My true wishes are equal division between Nathan and Renata. Nathan has been here. Nathan has been present. Whatever any document says that contradicts this, I want Nathan to know the truth. I love you both, but I know what happened. Dad, I sat on the edge of that bed for a long time. And then I called Margaret Okafor. Margaret Okafor had been referred to me by a colleague whose family had gone through a contested estate 2 years earlier. She was 51 years old, had a background in both probate and elder financial abuse law, and had the specific manner of a person who has sat across from a great many people trying to deceive the legal system and who has not found the experience discouraging but clarifying. When I sat in her office and laid everything on the table, the November meeting notes from Gerald's office, the envelope from my father, the calendar app records, the bank transfers, the text messages, she read through it with the focused attention of someone assembling a structure. When she finished, she looked up and said, "Mr. Cole, tell me about the will amendment. Has anyone explained to you how it was executed?" I said no. She said, "Then that's where we start. The will amendment, the document Renata had filed as the controlling instrument, had been executed 7 months after my father's November meeting with Gerald. It had not been prepared by Gerald's office. It had been prepared by a different attorney, one Margaret did not recognize from the Indianapolis probate bar, but whose name she wrote down carefully. It had been signed in that attorney's office with 2 witnesses and a notary. On paper, it was formally valid. Margaret said the question was not whether the signatures were genuine, but whether my father had possessed the legal capacity to execute a valid amendment, and whether the circumstances under which it was executed raised concerns about undue influence. In Indiana, she explained, undue influence in estate documents is a recognized legal claim that requires demonstrating that the testator's free will was overcome by the actions of a beneficiary. She said, "Based on what you've brought me, I believe we have the grounds to make that claim. What I need now is evidence. Documented, sourced, time-stamped evidence." What followed were 3 months of investigation that I participated in by providing every document I could access and that Margaret's office pursued. Through discovery requests, subpoenas, and depositions that began to surface information that neither Renata nor the attorney who had prepared the amendment had anticipated being surfaced. The attorney's office records showed that the amendment had been scheduled by Renata, not by my father. A scheduling email in discovery showed Renata contacting the office to arrange the appointment. The communication between Renata and the attorney, recovered through discovery, referenced the amendment and language that suggested Renata had described the general terms before the meeting with my father occurred. A medical record from my father's neurologist, subpoenaed by Margaret, noted that at the appointment immediately preceding the amendment signing, my father had demonstrated increased confusion and executive function decline, and that the neurologist had documented a recommendation for increased caregiver oversight. That appointment was 12 days before the amendment was signed. I want to pause here because this is the point in the process where I had to make a decision that was harder than I expected it to be. Margaret told me at the end of the 3-month investigation period that the evidence was strong enough to take to a formal hearing. She told me that the hearing would be in a courtroom with both parties present, that it would be a matter of public record, and that the evidence she intended to present would be, in her words, comprehensive and damaging to Renata's position. She said, "I want to make sure you understand what that means for your family relationship." I sat in her office, and I looked at the folder of documents on her desk, and I thought about my father at his kitchen table in late summer sunlight, sliding an envelope toward me and saying, "Keep this somewhere safe." I thought about the November meeting where he had sat across from Gerald Marsh and said he was concerned about conversations that felt like they were moving faster than he was comfortable with. I thought about 14 months of Sunday evenings and grocery runs and prescription pickups, and the Saturday morning, 2 weeks before he died, when he had held my hand and said, "Nathan, you have always been here." I said, "I understand what it means. I want you to proceed." The hearing was held in a probate court in Marion County on a Thursday morning in March. Renata arrived with her own attorney, a man named Hargrove, who was well-dressed and spoke with the practiced fluency of someone who manages his client's first impressions carefully. She arrived with Brad, her husband, who sat 2 rows behind her and looked at his phone. She arrived with 2 family members I had not seen in years who had apparently been told by Renata a version of events that positioned her as the responsible sibling, protecting the estate from exploitation. They sat in the gallery and looked at me with expressions that I recognized as the expressions of people who have been given a story and have accepted it. My father's pastor was there. 2 neighbors who had known our family for 30 years were there. It was, in the specific and uncomfortable sense of the word, a public forum. And Renata, when the hearing opened and Judge Howard asked each party to summarize their position, stood and delivered what I can only describe as a performance. She spoke about my father's wishes. She spoke about his desire to reward the child who had been most present. She said, carefully and without looking at me, that she had concerns about the influence I had exercised over a man in cognitive decline. She said it to the judge, to the gallery, to the family members who had come prepared to hear exactly this. She said it with the confidence of someone who believes the story they are telling because they have told it enough times. And when she sat down, she looked at Hargrove with a small, satisfied expression that I recognized immediately. It was the expression I had seen on her face on the morning of our father's funeral, when she had arrived at the house and looked at the furniture and the photographs and the rooms full of their history, and had said, "We should probably talk about next steps." Same expression. Same eyes, completed task. Margaret stood. She did not raise her voice. She does not operate that way, and I had come to understand in 3 months of working with her that this was not restraint but strategy. She said, "Your Honor, I'd like to begin with the medical records." She presented the neurologist's report. She presented it without editorial comment, reading the relevant section into the record in the specific undramatic language of a clinical document. The gallery was quiet, the date of the appointment, the note about increased confusion, the recommendation for caregiver oversight, 12 days before the amendment was signed. She moved to the scheduling email, Renata contacting the attorney's office to arrange the appointment for their father. She moved to the communication between Renata and the attorney, referencing the amendment terms. She moved to my father's handwritten letter, which she had had authenticated by a handwriting expert, and which she read into the record in full. My true wishes are equal division. Nathan has been here. Whatever any document says that contradicts this, I want Nathan to know the truth. The gallery went very quiet when Margaret read that letter. The family members who had come prepared to hear a story about my exploitation of a vulnerable man were now looking at a handwritten statement from the man himself that said the opposite. The pastor in the second row had closed his eyes. One of the neighbors had her hand over her mouth. Renata was looking at the table in front of her with an expression I had never seen on her face before and that I want to describe accurately. It was not shame, exactly. It was the specific structural collapse of a person who has built something carefully and is watching it disassemble in real time and cannot locate the point at which to intervene. Margaret moved to the calendar records. 14 months of appointments. She read a selection of them, not all selection, with dates and times. She presented the bank transfer records. She presented a statement from my father's pharmacist, who had submitted a written declaration, noting that I had been the person who picked up prescriptions on 23 separate occasions in the 14 months before my father's death, and that he had met Renata twice during that period. She presented Gerald Marsh's November meeting notes, certified by his office, documenting my father's specific concerns about financial arrangements that felt like they were moving faster than he was comfortable with, and his stated desire for equal division between his children. Hargrove objected at several points. Judge Howard sustained some objections and overruled others. The hearing was procedural, not dramatic in the Hollywood sense. And I want to be clear about that because I think the Hollywood version would include a moment of tearful confession or a dramatic confrontation across a courtroom aisle. There was no such moment. What there was instead was the slow and systematic dismantling of a false position by evidence that had been gathered carefully and presented precisely. The truth is that genuine legal proceedings are less about drama and more about documentation, and documentation in this case was overwhelmingly on one side. What would you have done in my position? Sitting in that courtroom, watching the evidence unfold, knowing that the people in the gallery had arrived, prepared to see one version of the story, and were now being given a completely different one by documents that could not be disputed, what would you have felt? I want to know. Drop it in the comments. Because what I felt was not what I expected to feel. I had expected relief or a victory or the specific satisfaction of a wrong being publicly corrected. What I actually felt, sitting in that courtroom watching Margaret present my father's handwritten letter, was grief. Quiet, specific grief for a man who had sat at his kitchen table 6 weeks before he died and written down the truth because he wanted to make sure it survived him. Who had known something was wrong and had done the only thing left available to him to address it. Who had trusted me with that envelope the way he had trusted me with every Sunday evening for 20 years and had been right to trust me both times. Judge Howard took the matter under advisement and issued a written ruling 14 days later. The ruling determined that the will amendment had been executed under circumstances that raised sufficient concern about undue influence, and the testator's legal capacity at the time of signing to render it invalid as a controlling instrument. The ruling reinstated the original will as the governing document. The estate, the house, the retirement account, the 2 rental properties on the east side of Indianapolis was to be divided equally between Nathan Cole and Renata Cole, as my father's original document had specified and as his handwritten letter had confirmed. The ruling noted specifically that the scheduling and circumstances of the amendment's execution had been initiated by a beneficiary in a manner inconsistent with the testator's independent decision-making, and that this pattern, combined with the medical documentation of cognitive vulnerability at the time of signing, was the basis for the court's determination. Renata did not look at me when we left the courthouse. She walked out with Hargrove on one side and Brad on the other, and she did not look in my direction. The family members who had come prepared to witness my exposure were standing in small groups near the entrance, and several of them looked at me differently than they had when we arrived. Not with apology, the moment was too fresh and too complicated for apology, but differently. The neighbor who had her hand over her mouth during the reading of the letter came over to me and said, quietly, "Your father would be proud." I said, "I know." She squeezed my arm and walked to her car. The pastor found me near the parking lot and said, "James talked to me about this, Nathan, more than once." I should have said something sooner. I said, "You're saying it now." He nodded, and that was the end of the public moment. Not dramatic, not triumphant, just the specific, ordinary closure of something that needed to be finished. Have you ever been betrayed by someone you trusted? Not a stranger, but someone whose betrayal required intimate knowledge of how you lived and what you believed and what you would not think to question? Share your story in the comments, because the betrayals that cost the most are never the ones from strangers. They are from the people who sat at the same tables you did and learned over years exactly where you were open. The estate was distributed according to the original will over the following 4 months. I will not detail the specific amounts because they are personal and because the money is not actually the point, though the money mattered in the practical sense of a high school teacher's financial life, and I will not pretend otherwise. The 2 rental properties required some management decisions, and I hired a property management company after consulting with a financial advisor. I took 3 months to make those decisions rather than 3 weeks because my father had taken his time with everything, and I had learned from him that patience and precision produce better outcomes than speed. The money from the estate did not change my life in the dramatic way that financial windfalls are sometimes described. It changed it in a quieter way. It gave me options I had not previously had, and the time to think carefully about how to use them. Renata and I have not spoken since the courthouse parking lot. This is not a relationship I am trying to restore in the near term, which is not a statement of anger, but of accuracy. What she did required planning and sustained effort over a period of years. It required the specific decision made at some point that I cannot locate, but that I know occurred, to use our father's vulnerability and her access to him as instruments of financial gain. That decision is not one I can bridge over with a conversation or holiday dinner. What I can do, what I have chosen to do, is not carry it as bitterness. Bitterness is the gift you give to the person who wronged you by letting them live rent-free in your daily emotional experience. I have not given Renata that gift. I have given her instead the consequence that the court provided, which is the only consequence that had both accuracy and proportion, and I have moved forward. I started seeing a therapist named Dr. Anna Webb 6 months after the ruling. Not because I was falling apart, I was not, but because I understood that the experience of watching a family member exploit a parent's illness required more than time to fully process. Dr. Webb and I have talked, over many sessions, about what it means to show up for someone without expectation, and then find that showing up has been reframed by someone else as manipulation. We have talked about the difference between being proven right and feeling right, and why those 2 things are not the same, and why the gap between them is where the real work happens. I am a better person for those conversations. I am a better teacher for those conversations, oddly enough, because what they have given me is a more precise understanding of what honesty costs and what it is worth. My students do not know any of this. They know me as the teacher who requires lab notebooks to be dated and sourced, and who tells them regularly that science is not about being right. It is about being willing to document your reasoning so that other people can evaluate it. I have said that to 16-year-olds in a classroom in Indianapolis, and I have meant it as a lesson about the scientific method, and I now understand that I also mean it about everything else. Document your reasoning. Keep the records. Date the entries. Not because you expect to need them, because the day you need them and have them is completely different from the day you need them and do not. My father's house sold 8 months after the estate was distributed. I drove by it once on a Saturday afternoon in November, the same kind of gray November afternoon that had opened every conversation about plans and next steps in the year before his death. There was a new front door, red, where his had been white, and the garden my father had maintained for 30 years had been cleared for a new layout. I sat in my car across the street for a few minutes. I thought about Sunday evenings. I thought about kitchen tables. I thought about the specific quality of light through the window over the sink on late summer Saturday mornings, and an envelope slid across a table by a man who had understood more than he let on, and who had trusted me to know what to do with it. I drove home, I made dinner, I called a friend. The ordinary life continuing, which is what he would have wanted. Here's what I want to say before I go, because I think this story has something in it that is worth saying clearly and not leaving implied. My father was not a sophisticated man in the financial sense. He was not a man who understood estate law or forensic documentation or the specific legal mechanics of undue influence. He was a machinist who had worked 34 years with his hands and had saved and built something real, and had loved his children with the specific, inarticulate depth of a man who did not often say the words, but always showed the work. What he understood at the end was that something was wrong, and what he did about it was the most human and most powerful thing available to him. He wrote it down. He put it in an envelope. He handed it to the person he trusted, and he said, "Keep this somewhere safe." He did not know about Margaret Okafor. He did not know about Indiana probate law or undue influence claims or handwriting authentication. He just knew the truth, and he found a way to preserve it. And the truth, preserved by a man in his last weeks in his own handwriting, was more powerful in a courtroom than anything else I brought. The lesson, if there is one, and I think there is not that revenge is possible if you are patient enough. It is not that the legal system always works the way it should. The lesson is that truth, when it is documented and preserved and placed in the hands of someone who knows how to present it correctly, is the most durable thing in any room. More durable than a carefully constructed false narrative. More durable than an amendment signed in an attorney's office by a man who was confused about what he was signing. More durable than the story Renata had been telling herself for long enough that she had forgotten it was a story. The truth was in a handwritten letter in a fireproof box in my closet. And when the moment came, it was enough. If this story meant something to you today, if it gave you something to think about, a person to call, a box to check, a document to locate, please like this video and subscribe to the Revenge Diaries and share it with someone who needs to see it. And before you go, one final question, simple and direct. Is there someone in your life right now who you trust completely to manage something that belongs to you? And have you verified recently that the trust is warranted? Drop your answer in the comments, because the answer to that question, in my experience, is the beginning of a much more important conversation. I will see you in the next one. And next week on this channel, the story of a business partner, a company account, and a single forwarded email that ended a 20-year friendship and started a very productive legal proceeding. You do not want to miss it.